Sudhal's only means of livelihood was her residential property in a small village in Gujarat, which her husband had left behind after his untimely death. Because of its remote location, the region was suitable for the local government to build a manufacturing plant providing local employment. Her house fell in between two plots of land where the authorities intended to build a factory. As a result, they offered Sudha the market value of the property. She accepted the compensation and relocated to a better place to spend the rest of her life and earn a living. Now, this is an example of the doctrine of eminent domain in a real life scenario. But what is eminent domain? The doctrine of eminent domain in its general connotation means the supreme power of the king or the government under which property of any person can be taken over in the interest of general public. However, over the years, such taking over of the property by the king or the government has been made possible only after compensating the landowner of such property. The expression eminent domain means permanent dominion of the state on the property. The power of the state to take private property for public use and consequent right of the owner to compensate now emerged from the Constitution of India. Eminent domain, as we now know, can be traced to the Latin term dominium eminens, which referred to a government's power to appropriate private property for the public's use, with or without the property owner's consent. It is based on two Latin maxims, salus populi suprema lex, which means that the welfare of the people is the paramount law, and necessitas public major est quam, which means that public necessity is greater than private necessity.
Tracing down the evolution of this doctrine, it goes back as far as 1066 AD when William the Conqueror seized virtually all the lands of England. The king retained absolute authority over the use and disposition of land. So landholders controlled land only as long as they performed the required duties and paid the required fees. The landholders were mere stewards for the king rather than being able to freely determine how the land should be used or disposed of. The idea of eminent domain as a power peculiar to sovereign authority but coupled with a duty to pay compensation comes from such 17th century natural law jurists such as Hugo Grotius and Samuel Pufendorf. The English practice in the early 17th century was for the Parliament to authorize the taking of property and either to prescribe the amount to be paid or to provide a judicial proceeding to determine it. The proceeding was held without the presence of the owner. The American colonies developed judicial proceedings enabling the owner to be heard on the question of compensation. The judicial definition of just compensation is the fair market value at the time of the taking, the market value including not only the existing use value but also the best use to which the property may be put. Nearly all other countries have constitutional or statutory provisions requiring that compensation be paid for property taken. The French and German systems, unlike Anglo-American law, require that it be paid in advance of the taking by the government. In the countries influenced by French and German law, the question of the public purpose to be served by the taking is an administrative one and is not determined in the regular courts.
In India, laws pertaining to eminent domain may be traced to the period of British rule, long before the Indian Constitution. Prior to colonization by the British, land in India was held by various systems of tenure depending on the location and the cultural heritage, but much of the land, particularly in northern India, was administered by a group of people referred to as zamindars. The zamindari system actually traced its root back to the Mughal Empire beginning in the 16th century. Though the zamindari system varied greatly by region, it was generally the case that those working the land did not own it but merely served as tenants and farmers. The British approached the administration of the land the way one would in a nation state, even though India was nothing of the sort at the time. To this end, the British focused their attention on land acquisition for the building of infrastructure projects, and they passed the first law to this end in 1824. In 1857, a number of Indian provinces rebelled against the rule of the British East India Company. The post-rebellion period saw various amendments to Act 6 of 1857, which provided for civil courts to determine just compensation in case of conflict. In 1894, the Land Acquisition Act was passed, which further amended and unified all land acquisition law pertaining to British India paid in advance of the taking by the government. In the countries influenced by French and German law, the question of the public purpose to be served by taking is an administrative one and is not determined in the regular courts.
After independence in 1947, many of the actual British regulations, including the Land Acquisition Act, were specifically incorporated into the Indian jurisprudence, that is Article 372 of the Indian Constitution. At the time the Constitution was being written, as much as 43% of the land in India was owned by the Zamindars. Article 19(1)(f) of the Constitution, as originally enacted, provided that all citizens have the right to acquire, hold, and dispose of property. Article 31 in return stated that only the state can acquire property for public purposes by the authority of law only after compensation is given to the landholders. Both articles were included in the Fundamental Rights section and both were eventually deleted. Some of the earliest amendments to the Constitution were Article 31(a) and 31(b), which immunized action of state governments that abolished Zamindar holdings from judicial review. In 1972, the court ruled in the landmark judgment of Keshavananda Bharati vs. State of Kerala that it was within the Parliament's power to amend the fundamental right listed in the Constitution, but not to change the basic structure of the Constitution. Free to alter the Part 3 of the Constitution, Parliament erased the articles regarding property and replaced them with the vaguely worded Article 300(a), which states, "No person shall be deprived of his property saved by the authority of law." This meant that the right to property was no longer a fundamental right, though it was still a legal right, which meant it would be governed by the statutory law. Many land reforms had taken place in the meantime, including tenancy reforms, sealing on landholdings, to name a few. At present, there are around 200 central legislation related to land besides the state legislation. Most of the amendments made to the Constitution are related to land. Since land is on the concurrent list of the Constitution's 7th schedule, many states have either severally diluted the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013 to skip basic requirements, or have completely bypassed the act by invoking outdated legislation through their power under Article 254(2). Many states also use these outdated laws to acquire land for purposes that may not strictly under the public purpose definition, such as constructing an oil refinery, building a factory, or opening a burial ground.
When most people think of eminent domain, they likely think of cities claiming residential or commercial properties to build highways or shopping malls, or simply due to urbanization. However, eminent domain actions occur in more rural areas as well, since the government wants to increase the residential, commercial, or industrial opportunities in these areas. Unfortunately, much of the land in rural areas is owned by farmers who depend upon their land for their livelihood. If they lose their land, they lose years of hard work building up their operations that likely cannot be recreated in another location. In 1947, the first Prime Minister of India, Pandit Jawaharlal Nehru, said, "Everything else can wait but not agriculture." In its fifth and final report, the National Commission on Farmers, headed by Dr. M.S. Swaminathan, observed that prime farmland must be conserved for agriculture and should not be diverted for non-agricultural purposes, else it would seriously affect the availability of food in the country, where 60% of the population still depends on agriculture and people living below poverty line are finding it difficult to survive. The focus of our discussion being the state of Chhattisgarh, Let us see how this doctrine has been incorporated in its local land laws. Subsection 1 of Section 57 of the Chhattisgarh Land Revenue Code of 1959 reads as follows: State ownership in all lands. All lands belong to the state government, and it is hereby declared that all such lands, including standing and flowing water, mines, quarries, minerals, and forest reserves or not, and all rights in the subsoil of any land are the property of the state government. This section deals with the theory of eminent domain, though the term has never been expressly used anywhere throughout the code. However, there have been restrictions which are put to the power of the state in exercising eminent domain, as has been provided in the latter part of the section. The proviso attached to subsection 1 strictly restricts the ambit of the section so that it cannot retrospectively curtail the rights of any person subsisting before the commencement of this code.
Now, let us understand how this doctrine had affected farmers in Chhattisgarh with the help of the famous case law of 2012, Gayatri Prasad and others versus State of Chhattisgarh. The Chhattisgarh High Court had caused the land acquisition order by state government for 4 power projects, including SKS Power, KSK Energy, Moser Beer and Visa Power. Justice Prashant Mishra held that the state had misused its power of eminent domain to acquire land since the coal-based power project did not constitute public purpose. The court called the acquisition a colorable exercise of power and asked the state to pay Rs 5,000 each as damage to each petitioner. The acquisition was done under Section 4 and 6 of Land Acquisition Act of 1894, which empowers the government to publish a notification regarding such acquisition if the appropriate authorities satisfy that the acquisition is done for public purpose. The court observed acquisition of agricultural land should be avoided and further that the agricultural land being the primary means of livelihood of agriculturists, it has the effect of uprooting the families, depriving them of their means of livelihood and social status. Therefore, acquisition of agricultural land for a company should not be made unless it is established that no other land is available for acquisition. In the present case, there is no such exercise undertaken by the state government before proceeding to acquire agricultural land, and whatever was the project and selection of land, the state government has really accepted the same to the detriment of the agriculturist.
A recent case of tribal rights vis-a-vis power projects has come to light when the Rajasthan Rajya Vidyut Utpadan Nigam Limited, a state electricity corporation, filed a plea before the Supreme Court that the state is running out of coal, which could lead to a severe power crisis in the state. According to the plea, over 40% of Rajasthan is dependent on the coal from Parsa mines for its electricity. Petitions over land acquisition of the Parsa coal block have been pending before the Supreme Court since 2014. Tribal communities have also moved the court over environmental concerns and the impact that the mining activities could have on tribal rights. The tribal groups claim that over 2 lakh trees in the Hasteo Aranya would be cut, leading to massive environmental damage. In June 2011, the Forest Panel under the Union Ministry of Environment, Forests and Climate Change had recommended against allowing mining on the basis of the ecological value of the forest and the amount of trees to be felled. However, they were overruled and the mining proposal was cleared. This decision was challenged in the National Green Tribunal, which suspended the mining work in 2014, but the order was stayed by the Supreme Court in an appeal filed by the RVUNL, where the matter remains pending till date. In July 2022, the Chhattisgarh government even passed a resolution to cancel the allotment of coal blocks due to the protests, but the demand was rejected by the central government in October since the allocation had been finalized as official procedure. During September to November 2022, Rajasthan faced a serious power crisis after the mining work was stopped in Parsa East and Kantawasan blocks. The RVUNL was forced to purchase coal at higher prices to meet the shortfall. The RVUNL said that while mining for Phase 1 of its project is ongoing, they would need to start Phase 2 due to the coal requirements of the state, which is hugely dependent on thermal power plants for its power needs. The Phase 2 projects have not started due to the ongoing protests. The matter is still pending before the court.
Eminent domain is an integral attribute of the sovereignty of the state. Simply put, it is the power that the state may exercise over all land within its territory. As eminent domain authorizes the state to deprive citizens of property rights, it need to be balanced with the right of citizen to lawfully hold, possess, and enjoy their private property. We have traced the evolution of eminent domain in India from the Constitution of India to the various land reforms that have taken place in India. The Land Acquisition Act 1894 enabled acquisition for development and infrastructure projects including dams, mining, and industrialization. This law was replaced in 2013 by the new Land Acquisition Act of 2013, which reflects a shift away from the policy of tolerating displacement and destitution as the necessary short-term consequences of land acquisition undertaken for the sake of economic development in the long term. It was widely been acknowledged as a tremendous step forward from the Act of 1894 in ensuring fairness in the land acquisition process.
In Chhattisgarh, there have been many issues regarding the acquisition of forest land, tribal land, agricultural land, few of which we have already seen. The Land Revenue Code of 1959 and other local land laws have tried to implement the rights of the landholders as far as possible, but like any other law, none are perfect. There is a long way to go before the owners of the land can be adequately compensated for their loss, and when there is no misuse of the power of eminent domain that is vested in the state. However, on a positive note, in 2019, the state of Chhattisgarh became the first state to give farmers their land back. As per Section 101 of the Land Acquisition Act of 2013, when a piece of land remains unused for 5 years from the date of taking possession, it may be returned to the original owner or put in the land bank. Some 280 cases were filed in the Supreme Court under this provision. In 95% of the cases, the court invalidated the acquisition proceedings. Many owners have either got their lands back or have been adequately compensated. The land spanning across 10 villages was acquired 10 years before for Tata Steel, which had proposed to set up a Rs 19,500 crore plant. But it was said that most of the land acquired for the project were fertile farmland. This gives us a ray of hope that the government is slowly realizing the rights of the landowners, and there are many checks and balances on the government when it uses its power of eminent domain. There is less scope, if not none, of misuse of this doctrine. We hope you liked this video. Thank you for watching.